Okay, so if anyone has anything they want to contribute, now is probably a good time before I launch into something. No one? No one at all? Okay. Well, I found a lot of things this week on, especially the early privacy, IP law stuff. So things prior to even the Statute of Anne. So there was way back when, way back when, there was the English Statute of Monopolies, and this was in response to patents from the king were being handed out left, right, and centre to whoever would pay for them or whoever was in high standing. And they allowed monopolies for anything, even up to things like salt. And so the Statute of Monopolies came in and abolished all of these monopolies. And it started up the very beginnings of it was really, the purpose was to prohibit monopolies rather than to promote invention, which is one of the core things about IP law, obviously, is encouraging the individual to create and to have those certain protections so that they want to create. And following that is, the Statute of Anne. So that regulated the printing and it vested copyright in the creators rather than the publishers. And it was, the reason that it was so important was because it recognized that authors were the creators of what they made, and it stopped all the people with their printing presses from making a million copies of the books, as we've said in weeks before. And it, from there on, we've had a whole bunch of different things. So a lot of the things that, the things we've been asked to consider this week are like the development of the IP policy, points of view from the consumer, the creator, and the publisher. So as we go through, I'll just, I'll try to keep that in mind. So the first one that's down in the timeline is newspapers and telegrams. So obviously the telegram was not necessarily, I don't know if that one really fits as well. I suppose it sort of does because it allowed the exchange of ideas from one place to another over long distances. But newspapers especially, I know from our readings, we had that article in there about the Associated Press and all of the things going on there. So, as a consumer, consumers want to know the news, and that's where they were getting it, was from the newspapers. But the newspapers all compete with one another for all of their ideas and things. Yeah, exactly, Scott. They allowed people to keep things that were important to them and to find out all the different things that were happening all over the world. And for publishers, especially for newspapers, they have to be current. The main thing is you have to be there first. If you're not the person who breaks it, then yeah. Sorry, if someone wants to contribute, you're more than welcome to. Please make me stop.
Yeah, using both the channels at the same time is a tricky skill to get used to, and I've found it a bit of a learning curve. But I do think it's a lot easier than trying to get everyone to speak at once. But you can always ask us questions. If we type something interesting in there, you can throw it back to one of us.
Okay. So I suppose that's probably enough on newspapers. I think we can all realise how important they were, and we've all read the readings, obviously. But then that leads to the next one in the list is the radio, and I think along with the radio is the invention of that early era of music that came out, and I think that's very important for IP law. I think there are a lot of different cases that came out around that time. Does anyone have any? Anyone find anything about, maybe records and publishers especially? I think this is when the rise of the publisher would have come about. No? Well, I didn't run into that much. And I think, oh, there we go. Yeah, so that's what Scott said in the chat is something that I've noticed a lot is that, you know, radio was a very free sort of thing, you know, like most things, like the internet. It's very unregulated, like the Wild Wild West sort of scenario that we've got going on in our readings. So we move on to the 1960s, which is the cassette tapes, and someone has written in the controversies section that recordable media allowed consumers to record content from radio and other recording sources. So that's probably one of the earliest, other than the printing press and maybe some scientific inventions, it's probably one of the earlier ways that an individual consumer could be able to interfere with intellectual property rights. So obviously you could record the shows that actually mattered to you, like, you know, War of the Worlds and all of that sort of stuff. Does anyone have anything else? Did they find any changes to the IP law around that time, or?
Yeah, while we're still on radio, there was an interesting, I don't remember the citation of the article, but there was an interesting history piece that suggested that radio was almost like the first internet. There was almost this amazing explosion of citizen band radios where people could talk to each other and could communicate in new ways. And governments were so scared of that, they quickly regulated the way in which CB radio happened. So it's quite interesting, a comparison that when that happened, there was this huge knee-jerk reaction. When the internet started, most people just went, oh, it's a bunch of nerds talking about Star Trek. It's never going to take off. No one cares about the internet. So the opportunity to regulate it passed by. And then we got this very, very different flow-on effect. It's very difficult to start regulating now.
Yeah. I can't wait to get to the internet section because I'm obviously very interested in that section. Something very near and dear to my heart. So in the 1970s, we have here double cassette players, which allowed for more easier copy, even if someone didn't know how to wire together audio. So obviously inventions like that, well, even the invention itself would be covered by patent, I believe, and it allowed for the interfering of the rights and more power to consumers and things like that. And then we have VCRs. So, and there's a case for Sony Corp of America versus Universal City Studios Incorporated, which I haven't read, unfortunately. But does anyone want to give me a brief overview at all?
I can jump in on that one. It was called the Betamax case. And what happened was Universal, funny that Sony was the defendant in this case, Universal, basically the allegation was that all the VCR was good for was ripping off people's IP. There was nothing you could do with a VCR that was legitimate apart from basically copying stuff off of TV, or if you were clever and had two VCRs off of another tape. And quite interestingly, the American courts, and we'll look at this again next week when we look at fair use, they said that time shifting was fair use. What I mean by time shifting is saying, my stories are on during the day, I'm working during the day, so I record Days of Our Lives so I can come home and watch it at night. Because I can't watch it at that time, or something's playing late at night, I can't watch it, then I record it so I can watch it late at that. And the courts stunned everyone by saying that was fair use. So the Betamax went from being this new invention that looked like it was going to get regulated out of business because it looked like it was nothing but a piracy machine, to something which, well, it's now dead in the water, but it was something that became very pervasive.
Well, I think the next one is the 1980s, which is CDs. I would say there are a whole bunch of cases if anyone's seen anything about the CDs. Anyone who wants to contribute? Anyone? Well, I know there are a whole bunch of them. I'll have to go strolling through my notes to find them though. But well, we can always just move right along. Format shifting.
Yeah, like time shifting. If you've already bought an album on vinyl and it comes out in CD, and you make a copy to a CD or a tape or a digital file, is that fair use? Is making another copy in a new format when you've already bought the original? And the answer is, within limited conditions, yes, it is a form of fair use.
I think something similar like that is happening with, you buy a CD and then you get it in iTunes. I think is those sorts of things are still going on. So we can jump ahead to DVD and Blu-ray copy protection, which a whole bunch of people have contributed to, I think. So.
G'day, Sheridan. Can you hear me okay?
Yes, I can. Thank you.
All right. Sometimes I have a bandwidth problem, so I'll apologise in advance. Most of that DVD, Blu-ray stuff is me. It was when I went through the readings, I found that I just gravitated towards a specific topic and then I just focused on that. So I didn't really go through the print media and cassettes and things like that. But what I found fascinating was not just the sort of like the DVD, Blu-ray technology for the design of the discs themselves. What I found fascinating was the copywriting of materials and the technology that went into providing protections so that, to prevent people from copying DVDs and Blu-rays. And the way that I guess the commercial entities, the corporations who had the most money vested in it, how they sort of lobbied and pressed the government for change in terms of protecting those copyright protections. And there was just an interesting case that sort of came up through that, which was about what were they called? The AACS, which is the actual technology. They instigated proceedings against a company called DVD Fab, who made a ripping software where you could sort of, rip videos and Blu-rays onto a hard drive. And it just sort of read a lot like, big corporate influence in terms of pressing this. But the thing that sort of came out of this to me was not necessarily the specific laws themselves. And I had a look at some of the US law and the Australian law in terms of the Copyright Acts. It was more how sort of they evaded the laws and simply closed shop in the US and set up in another jurisdiction in China. And they've just continued business as usual. And from anecdotally what I've read, it seems like there was absolutely nothing that could be done to stop them. So all they did was set up in a jurisdiction. China and the United States are not particularly friendly, particularly when it comes to legal matters. And I can't see, when looking at this, how sort of legislation could accommodate those type of changes and sort of the globalised aspects of this. So that's sort of, I'm heading off on a different tangent, but that was the thing that sort of I started looking at.
I actually did find some international stuff. So I'm not quite sure how to pronounce it, but I'll just type it in chat in case you guys want to Google it. And that convention was first established in 1886 and was renegotiated in 1896, 1908, 1928, 1948, 1967, and 1971. And it was all about keeping a number of core features across international lines and making sure that everyone sort of had protections in place for their for the artist, and I guess because of the creation, publishers have the power that publishers have. Also protections for publishers, as it will always turn out to be. Well, as far as we know. And so, yeah, no, that's super great. Thank you so much. Yeah, free trade agreements, the 2000s. It is, IP law has been very well represented in international law, although I'm not very, I haven't done international law, I'm afraid, so I feel a little bit out of depth when I look at it all, but they're fairly well represented, even though China has always been, you know, a little bit out of step. Now, the next one in the list is Netflix Australia for the 2010s. And I think that one's very important because it's, oh, sorry, I won't move on until everyone has said their little piece in the chat.
Yeah, sorry. Just before we went on to Netflix, which was my little contribution, which I've been experimenting with all day. I also wanted to, I suppose, we're talking about like CDs and that sort of thing. I noticed here that Scott put a really interesting case in the notes here to do with a High Court hearing a case about CD burners, and I'm going to pronounce it wrong, but I was like, oh, sorry, going back to like week one, that one about the CD burners, that was Sony Entertainment, and I think it was a High Court case where someone had like a ripping software, crack software to do with getting into the PlayStation to play copyrighted material, and then contrast that with a case I think I saw this week, also in the notes, where they're talking about, I think, CD burners as opposed to the PlayStation one, where that was seen as all right. Sorry, I'm being real vague here because I haven't read the case in full. When you were talking about all this stuff just now, just clicked in my head and remembered that one we were talking about, all that sort of stuff. So, yeah.
Yeah, I think we find that the government is often very compliant under free trade agreements to jump when the US copyright holder stake interest groups jump. And then you find that when it finally comes to the courts are a little bit more conservative about these things and these changes. And when people fear that, you know, it's going to mean this new draconian set of laws, it's quite surprising that even a fairly conservative bunch like the High Court will turn around and go, no, we're not going to apply these laws just because America wants us to.
So my question, I suppose, is it, from what you've reading through your cases and everything, Sheridan, and going off what Scott said as well, is it of your opinion that the High Court has been leaning towards, I suppose, the sharing of information as more a priority than, I suppose, the intellectual property owners retaining their profits and their monopolies?
Well, in my readings so far, it does seem that, well, one of the basic things about intellectual property rights is the fact that the commons are so integral to all of this. You have to have a certain amount of protections for the creator, but mostly, you know, like patents, the patent trade-off. So you have to make it all public, and how it is like created, whatever it is that you've invented, is given to the public, but you keep those rights for yourself, at least for a period of time. And that struggle, so far as what the High Court has said so far, it seems like how it impacts upon the consumer is very important. So there was that case with, the hacking, and they were like, and I think it comes back to the Netflix thing. I don't think if anyone had been pulled up on Netflix charges, you know, for pirating, say, Game of Thrones, I don't think anyone would have been that harshly, I don't think the High Court would have sided with them, to be quite honest, because it's so hard to get it. You can't, there is such a time gap and a price gap between America and the US. And so Netflix, now that we have access to Netflix, even though it doesn't have, say, Game of Thrones, it has a whole bunch of other things. And I think that because we now have that access, and because it is more fair, you know, you just have to pay a small fee and you get it every month, the High Court is much less likely to side with someone who's pirating these sorts of things. And I wouldn't even be surprised. Sorry.
So your theory is that now that I suppose with the introduction of Netflix today, the hurdle of trying to get things affordably and accessibly and almost, and relatively immediately, though there is an imbalance between us and America as long as Fox holds exclusive rights. Your theory is that because the balance has swung back towards the interests of the commons, so to speak, if the High Court was to hear another big pirating case, something like that, you think they might go back towards the IP rights holder because the interest of the commons, is being upheld because of Netflix?
Yeah, I think that the protections for mainly the publishers with things that are on Netflix, it's really an individual sort of, you're not an individual artist if you're on Netflix. I think that those rights are protected, would be more protected, because that is what the legislation is there for. But the consumers aren't as poorly off anymore.
I'll rephrase because I word that really poorly, and it comes back to, I suppose, your workshop, dear leader. How do we balance the interests of the people's intellectual property, the owners of the intellectual property, and society's need or right, I suppose, to benefit from those ideas? And using an example that we had in the readings this week, Mickey Mouse, was invented originally in like 1928. We're almost 100 years on now since that was around, and it's still not in the public domain. And if it was something like a symphony or an equation or a medicine, this would be reprehensible for it still to be, I suppose, denied from the public. So clearly we can see there's a bit of imbalance there. So how back to my original question, how do we find that balance? And what do you think the best formula is, if there's a formula?
Well, that is a very, very difficult question. I think that is kind of the core of the whole course. But I think a very important aspect in to contrast between Mickey Mouse and, say, a medicine. Medicine is so beneficial and it can be so costly. And I think that the general good that can come out of those sorts of things is so high that it needs to be public. Whereas Mickey Mouse, he's cool and everything, but he's not he could be beneficial to other people. I mean, there are going to be, eventually one day it will be in the public domain and there will be so many jokes and so many cartoons and all of that. And I think it comes down, especially it's about money in America and the lobby groups, and it's the biggest thing, particularly in America. Luckily, we have less of that in Australia, but I don't know if there really is a way to do it. And especially you look at things like on the internet and the individual, I think finding that balance between the protecting the IP rights and protecting the commons it's so blurred, and I think it really is a case-by-case sort of thing. Thank you.
I think you did a fantastic job there, and I grilled you pretty hard. Well done.
Okay. Oh. Yeah, I think that AC/DC thing is a very interesting point, and particularly with how the internet works at the moment. And I had a very long think about this and how bands, there was that in the readings, there was that example of his band, and he writes the songs for his band, and he's never gotten a cent out of it. But that's not the point. The band has always allowed people to tape their shows, and they're one of the best-selling shows in America. And that's because people know about them. And the thing is, on the internet, currently the currency is really popularity. And I think it comes back to things, there are a whole bunch of different ways that it's going down to, but like popularity. You know, you sell your T-shirts. You know, release your music for free, sell your T-shirts, as Scott said earlier. And people on the internet are realizing that the money needs to come in from somewhere, so you need to support the things that you like. And so there are sites like Patreon, so you can pay for different YouTubers are on there. There are things like Crash Course, which does like science, it does history, and you pay a monthly fee, and yeah, it's a great site. I use it all the time actually, and I support a couple of artists on there and things like that. And it goes back to, in the readings, one of the suggested theories was that the way that things are going to have to be is that we're going to, like, artists are going to have to go back to the way it was, say, you know, Michelangelo and things like that. You had patrons that would pay for your work. And it's kind of going back to that, but you have so many more patrons because it's a global sort of access. And I think that's the important new thing is, you know, the information economy and all of those sorts of things.
So, in your opinion, based on the trend and the way things are going now, you know, we've gone from once upon a time radio to cassettes, can copy from one cassette to another, to now with such prolific pirating that it's just unreasonable to think that it's ever going to stop. And then we got cheaper and cheaper access to content like Netflix. At the end of the day, is it going to become impossible for people to really trying to get money for their intellectual property? Are they going to have to look for novel ways like what you're talking about right now to get, you know, money for their work? Is pirating legislation one day going to be so redundant because it's so unenforceable?
I think there's a possibility, and in the readings that came down, there was this mention of encoding things and keeping things, because there is still information on the internet that needs to be kept secure in order for you to, you know, make enough money off it and whatever you wish to do with said information. But, you know, and there's this arms race between people who encode and people who break the code, and that's a constant sort of theme. You know, you get, when people make new software, it is actually a really good assignment topic. When people make new what am I trying to say here? People make new software, so they can sometimes hire white hat hackers, as they call them, to find the holes in those, and then, you know, try and fix it from there. Do I think that it will ever be non-existent is the question. I think that this whole popularity and crowdfunding thing is very interesting, and that social media has been a very, very big thing for this. You know, you go on there, you make something really cool, and you just hope to get the likes from it instead of actually making money. But that's not going to always be the way that it is.
I can think of one situation where IP law still is very strong and works very well, and that's stopping organisations like Time Warner or the big companies in ripping off individuals. So it may not be very good at catching consumer pirates, but it was never designed for consumer pirates. What it means is if I create a fantastic new song, and put it online, then Lady Gaga can't steal my song and record it and make lots of money out of it, and Warner can't make lots of money out of it. So the IP law still does what it was designed to do, which is regulate the producers who have all the resources, but they've made us think that it's actually about piracy.
Is that good enough for you, Michael? These are very hard-hitting questions, and I appreciate them very much.
That's all right. I can't help myself. Thank you. That was very good.
So back to the timeline, which we are supposed to be doing. The last one on the list is Apple versus Samsung. So in the controversy column, it says is mass storage, controlled hardware with a central publishing system. And the final column says, in 2010, Apple finally received 38 patents on its iPod, which was in production since 2002. The scrolling was the first patent sought. So I actually don't know very much about this. Does anyone want to explain it to us?
That was my mega contribution, because I'm an absolute Apple junkie, and every time I've purchased an Apple product and it's died after killing it for 12 months, I've decided to go buy a Samsung, and then within 2-3 months of buying a Samsung, I go back to the latest Apple product. Ergo, iPhone 6 Plus, MacBook Air, iPad, iPod. I wanted to name my daughter Apple, but Gwyneth Paltrow got to it first. So what I found interesting about this, though, was that Apple launched a multinational lawsuit against Samsung, almost in every jurisdiction, including Australia, for breach of its patents, or colloquially, its IP. And in reading some of the lawsuits, it was over things like and you can type a pin or whatever. But remember, in the first iPhones, there was that little slide bar. And am I frozen? Can you?
It's okay. It's back now. It's back now.
It's back? All right, okay. I was saying.
I just have to go back a couple paragraphs there, because I think we missed you for like 20.
Okay. What I was saying was that Apple was suing because of the way you unlock the phone. That was one of the things, and the fact that the iPad and the Samsung Galaxy Tab 10.1 were the same shape, the same size, except rather than being charged at the bottom, the Samsung had to be charged in this location. And there's a federal court case which Apple won an injunction. The High Court refused, overruled, and on appeal, the High Court quashed the injunction and let the Galaxy Tab get sold. What I found ridiculous about this is that smartphones are pretty much all the same these days. Apart from Apple, you've got Apple or Android as a general sort of term. Why is there even a fight about it? Because in my opinion, it comes down to personal choice. You either want an Apple product or you want an Android product. Does how it unlocks really affect sales? From what I see from colleagues and friends, it's mainly a preference. I know I can see Kit's point about it being a monopoly, but does that monopoly necessarily increase sales? If you want an Apple product, you'll go and purchase it. If you want an Android product, you'll go and purchase it. How it unlocks is not necessarily the be-all and end-all of why you are making that choice.
Okay, so I have 2 points on this. First of all, before the iPhone came out and the iPod came out, there were a whole bunch of different phones you could get. You could get your flip phones, you could get your monologue phones. They all had buttons on them. It wasn't on the screen. Following the release of and success of the iPhone, all of them have now turned into, this. And also, my second point is that Apple really prides itself on its exclusivity and how it's unlike everything else, and it's a leading frontier, and it's exclusive, and it has that exclusive price tag. So I think these sorts of things, although they seem so minor, matter to the brand overall.
But does that actually affect its IP? When you look at, to go back to your example of the digital and analog phones we used to have back in the 90s, my first phone was a Nokia Brick, and I remember it was such a great thing when you could add a ringtone to your phone. Now I can load movies and edit documents on my phone and do my banking on my phone. I don't even have to leave my office. But that functionality is common now. So that functionality is common to everything. And even if Apple could stop Samsung from copying its slide. The Google system is so open that I can create an app, put it on Google Play, and download a lock feature that mimics Apple. You can get these themes which do that. So when I read some of the stuff about these cases from Apple versus Samsung, I'm wondering, are they just going after Samsung because Samsung has the deep pockets? Or should they really, or is the real person who's offended the IP the software producers or the app producers that have put things on Google Play? That's another option.
Well, I think deep pockets are a prime consideration in almost every law case. And I think it comes down to this, it's that struggle between the commons and the individual sort of thing again. Like, I don't know how to express this very well.
Well, if I may, when you were talking there, Samuel, I kept thinking, you know what, Apple sounds like a bit of an IP troll here. And I can, the reason why I'm getting frustrated along with you is because I'm thinking that the idea of releasing a patent for something is that it's out there in the public domain, as Scott talked about in week 1, so that somebody else can have a look at it and then improve on it. And then we basically make society better as a result. So if picking a small feature that somebody else has mimicked, but I suppose improved upon, is I suppose the point of IP, then why should it be that they think that that's an infringement? Again, this is a question of balance. I don't know, but just yeah. What do you think? It sounds like a bit of a troll to me. That's all.
I mean, to touch on Sheridan's earlier point about the balancing between the interest of the IP against the interest of the commons, is anyone really suffering as a result of a slide function on an unlock? When you look at medication, and I know this from my wife, she works in for a firm called ResMed that makes sleep apnea devices. Those devices have a particular algorithm, and they regulate breathing and sensors and all this sort of stuff developed by all these wonderful biomedical engineers. Their competition out there, I think, is Philips and someone else and a few people that manufacture these devices. They've spent millions of dollars in R&D to develop an algorithm to save people's lives. So protecting that IP, balancing that against their investment, I can understand. But looking at the Apple and Samsung cases, I think it's frivolous, considering I could buy an Apple knockoff that will run a very similar operating system that'll look, talk, and walk like an Apple off eBay for $100. So is it just a comment that Scott made earlier, was that it's probably a bit self-serving of the lawyers saying they've breached your IP, there's legislation, let's sue. But is that really what the legislation would have intended in protecting? It just seems like it's just two bullies in the marketplace trying to pick a fight with each other.
So what was the end result from this dispute? Has the case been through the courts, or who won?
It's on its second appeal, but money keeps changing hands. Like the current one is a Samsung's violation of 5 further Apple patents for its new products. Every time they release a new product, Apple sues. So the Samsung Galaxy X6 is out, which the bottom of it looks a lot like the iPhone 6, so they're suing for that now. And Samsung has a counterclaim for $6 million, while Apple is claiming damages of $2 billion worldwide. So that's why I chose IP law. I want to get some of that action.
Well, it's quite a lot of money. I don't know. It sounds very frivolous, and I guess that's probably not what the legislation intended originally. It's written, and I think this is something that's very important from the notes was the fact that this sort of, the laws that we have are relating to property rights, and they're relating to usually tangible things, and they're being applied to things that are more ideas, and they're numbers and they're zeros, and it doesn't quite fit the mold, and it's just not quite going with it all. And I think relating back to all the stuff that's been happening in the chat about the car one is very interesting, because like cars always take so long to like build new shapes of their cars, and then new motors, and then there's all these new things always coming out, and yet they always patent it, and it always takes so long to get a new one, and it really just saves them a lot of money, I think, is the biggest thing. Yeah. Oh, okay. Do you want to tell us about the procedures, Scott? That would be great.
Not tonight, because we're running out of time. But yeah, there is procedure. If you think someone is sitting on a patent, and just so to stop anyone else using it, there is actually an application you can make under the Patents Act, and proving that, of course, is another thing, because they'll say, "Oh, it's in research and design, and we're developing blah blah blah." But if you can actually prove it, you can actually force them to release. There's a whole sort of conspiracy theory around electric cars, and that the Ford's been sitting on all these patents, secret patents for electric cars since the 1920s and whatever else. But A, if it's a patent, it's in the Patents Office and it's public, and B, patents don't last that long. C, even if they did last that long, you could get them released. So we'll put those ones down to conspiracy theories. If you don't register a patent and just keep it secret and pay people off and send the Men in Black around, then there, you can do that. That's one way to stop it. And when we talk about sitting on a patent, it is a registered patent, but what you can do is you can register something just to stop someone else using it or exploiting it, but that's seen as a misuse of patent law. It's provable. Anyway, we're running out of time. So have you got some final thoughts, Sheridan?
Well, thank you all for dealing with my stumbling and bumbling. I get very flustered. I'm much more of a write it down sort of person than a speak it out sort of person. So this is a little bit of a challenge for me. But I think that the historical developments and the fact, what's really interesting to me is how ill-suited the current laws are, and how they're failing to deal with the current, internet and the piracy and the breakdown of all of these things, and the growth of the commons in comparison to publishers' rights is very interesting to me. So I hope we all enjoyed this week. Thank you.
Yes, thank you. Well done, especially jumping in on the first topic like this, because I know it was it's sort of scary to jump in first, and as I said before, dealing with the two channels is definitely an acquired skill, but it's certainly, as someone who's been teaching for 20 years, it certainly is a fantastic tool, because ordinarily in the face-to-face tutorial, I'd ask questions and everyone would just not talk about it. So at least here we've got another channel for people to keep chatting. So yeah, thanks guys, thanks for being engaged with the discussion. I'll stop the recording now.